On May 21, 1924, in the wealthiest neighborhood of Chicago, two brilliant young men committed what they believed was the perfect crime. They were sons of millionaires. They were academic prodigies. They were 19 years old, and they murdered a 14-year-old boy, simply because they wanted to prove they could. What followed would become the trial of the century. A courtroom battle that would force America to confront uncomfortable questions about wealth, privilege, the human mind, and whether anyone truly deserves to die. This is the story that changed American justice forever. Chicago in the spring of 1924 was a city of roaring contradictions. It was the Jazz Age, an era of unprecedented prosperity, bathtub gin, and rebellion against the old ways. Prohibition was the law of the land, but bootleggers like Al Capone operated with near impunity, turning the city into a battleground. Yet, far from the speakeasies and gangland violence, in the opulent mansions of the Kenwood neighborhood on the city's south side, the children of Chicago's industrial elite wanted for nothing. This was the world of Nathan Leopold Jr. and Richard Loeb. Their families represented the pinnacle of the American dream. The Leopolds had made a fortune in shipping and manufacturing. The Loebs were titans connected to the Sears, Roebuck and Company empire, one of the largest retailers in the nation. Money, status, opportunity, these young men had inherited it all. Nathan Leopold was 18 years old and already a phenomenon. He had graduated from the University of Chicago at just 17, the youngest graduate in the institution's history. He spoke a reported 15 languages, some fluently. He was a published expert ornithologist who had lectured on the rare Kirtland's warbler. His IQ was measured at 210, a number so high it was almost off the charts, bordering on the theoretical. By every metric, Nathan Leopold was a certified genius. Richard Loeb, also 18, was Leopold's perfect foil. Where Leopold was awkward and intellectual, Loeb was magnetic and effortlessly charming. He, too, was a prodigy, graduating from the University of Michigan at 17, the youngest in his class. He was handsome, athletic, and popular. He came from a family so prominent that his father was the vice president of Sears. But behind that dazzling facade, Richard Loeb harbored a dark and all-consuming obsession: crime. Since childhood, Loeb had devoured detective novels. He didn't just read them, he studied them. He fantasized about committing the perfect crime, a crime so flawless, so intellectually superior, that no investigator could ever solve it. It was a fantasy that grew from a childish game into a dangerous fixation. And in the introverted, brilliant Nathan Leopold, he found the perfect partner. They had known each other for years, neighbors in the exclusive Kenwood enclave. But their relationship had deepened into something far more complex and toxic. Leopold, by his own later admission, was infatuated with the charismatic Loeb. He would later describe Loeb as his king, a master for whom he would do anything. And Loeb, a master manipulator, was more than willing to exploit that devotion to make his darkest fantasies a reality. In the months leading up to May 1924, they had been practicing petty thefts, acts of arson, elaborate deceptions. All were rehearsals for their grand performance. What they were building toward was something far more sinister: the kidnapping and murder of a child. Not for ransom, not for revenge, simply to prove they could. May 21, 1924. A warm Wednesday afternoon, the day of the performance. Leopold and Loeb set their meticulously crafted plan in motion. They had rented a Willis Knight touring car under a false name, Morton D. Ballard. They had purchased a chisel, rope, and hydrochloric acid. They had typed a chillingly precise ransom note on a typewriter stolen from Leopold's fraternity. Every detail was in place. Now they just needed a victim. They cruised slowly past the Harvard School for Boys, an exclusive preparatory academy where both had once been students. They knew these streets, these families, these children. They were looking for a target of opportunity, an easy, convenient victim. Robert Bobby Franks was 14 years old. He was the son of Jacob Franks, a wealthy watch manufacturer who lived just blocks from the Loeb family mansion. Bobby was not a stranger. Richard Loeb knew him well. They were distant cousins. Bobby had played tennis on the Loeb family court. When he saw Richard Loeb's familiar face, he would have felt safe. He trusted him. What happened next would traumatize Chicago for generations. Leopold and Loeb pulled their rented car alongside Bobby Franks as he walked home. Loeb called out to him, offering a ride. Bobby, only a few blocks from his house, initially declined. But Loeb was persuasive, mentioning a new tennis racket he wanted to discuss. It was a casual, friendly invitation. Bobby climbed into the front passenger seat. Within moments of Bobby entering the car, the attack began. Concealed in the back seat, one of them, Leopold or Loeb, each would later blame the other, struck the boy from behind with the chisel. Bobby was bludgeoned repeatedly. He died within minutes, bleeding to death on the floor of the rented automobile. He was 14 years old. As darkness enveloped the city, Leopold and Loeb drove toward the desolate marshlands near the Indiana border. They carried the body to a remote drainage culvert near Wolf Lake. They stripped Bobby's body, poured the caustic hydrochloric acid over his face and genitals to obscure his identity, and then shoved him into the pipe. They believed no one would find him for weeks, perhaps months, perhaps ever. Their grotesque work done, they returned to Chicago. That night, they mailed their ransom letter to Jacob Franks, demanding $10,000 for his son's safe return. It was an elaborate piece of theater, complex instructions for how to deliver the money, dire warnings not to contact the police. The ransom was never about money. Leopold and Loeb were already wealthier than the Franks family. The ransom was simply part of the intellectual game. It was the final move in their perfect crime. "Dear Sir," the letter began, "as you no doubt know by this time, your son has been kidnapped. Allow us to assure you that he is at present well and safe." But in their breathtaking arrogance, Leopold and Loeb had convinced themselves they were Nietzschean supermen, being so intellectually superior that they were beyond ordinary morality, beyond consequences, beyond the reach of human justice. They were wrong. The morning after the murder, before the ransom note had even arrived at the Franks' home, a Polish immigrant worker named Tony Mink was walking near the Wolf Lake drainage culvert. He spotted something pale and unnatural in the water. What he found would unleash a firestorm. Bobby Franks' body was discovered less than 24 hours after he was murdered. The acid had disfigured him, but not as thoroughly as Leopold and Loeb had hoped. The boy was quickly identified through dental records. The news hit Chicago like a physical blow. The son of a prominent, respected family, brutally murdered for no apparent reason. The city screamed for justice. And then investigators found the crucial mistake. A single object lying in the mud and muck near the body, a pair of horn-rimmed eyeglasses. They appeared to have fallen from the killer's pocket as he stuffed the boy into the culvert. At first, it seemed like a long shot. Thousands of men in Chicago wore similar glasses. But the lead investigator, Sergeant William Blall, noticed something unique. The glasses featured an unusual, patented hinge mechanism. It was a detail so specific that the manufacturer was able to tell police it had been sold to only 3 customers in the entire Chicago area. 2 of them had rock-solid alibis for the night of May 21st. The third was a brilliant, 18-year-old law student named Nathan Leopold Jr. When confronted, Leopold was unruffled. He had a ready explanation. Yes, those were his glasses. He must have dropped them on a recent bird-watching expedition. After all, he was a famous ornithologist. He frequently visited the marshes to study bird life. It was an innocent, if unfortunate, coincidence. State's Attorney Robert Crowe, a politically ambitious and ruthless prosecutor, was not convinced. He began digging deeper into Leopold's alibi and into his intense friendship with Richard Loeb. The 2 young men claimed they had spent the evening of May 21st driving around in Leopold's car, drinking bootleg whiskey, and trying to pick up women. Their story was detailed, elaborate, and perfectly consistent. Perhaps Crowe suspected too perfect. Then came the break that shattered their story. The Leopold family chauffeur, a man named Sven Englund, told investigators something that directly contradicted Leopold's alibi. Leopold had claimed to be driving his own distinctive red Willis Knight car that evening. But Englund testified that he had been working on that very car all day and evening. The brakes were being repaired. The car had never left the family garage. Simultaneously, Investigators obtained samples of Leopold's typewriting from his law school study group notes. Forensic document examiners compared the typeface to the ransom note. The quirky, slightly misaligned letters were a perfect match. The ransom demand had been typed on a portable Underwood typewriter that Leopold had borrowed from his university. A typewriter he had later tried to dispose of by throwing it into the Jackson Park Lagoon. The perfect crime was falling apart piece by piece. On May 29, 1924, 8 days after the murder, Leopold and Loeb were brought in for intensive separate questioning. For hours, both young men held firm, reciting their carefully rehearsed alibis. Then, in the early hours of May 30th, after a long night of relentless interrogation, Richard Loeb, the charming master, finally broke. Loeb confessed everything. He described the planning, the kidnapping, the murder, and the disposal of the body. He spoke with a chilling detachment, as if describing a complex intellectual exercise that had simply gone wrong. But in a final act of self-preservation, he blamed Leopold for the actual killing, claiming Leopold had been the one to strike the fatal blows. When told of his partner's confession, Leopold's confidence shattered. His king had betrayed him. Within hours, he too admitted everything, with one crucial difference. Leopold insisted that Loeb had struck the fatal blows. Each blamed the other for the ultimate act of violence. But on the fundamental facts of their guilt, there was no doubt. Nathan Leopold and Richard Loeb had planned and executed the murder of Bobby Franks. And now they would face justice. The trial of Leopold and Loeb became an immediate international sensation. Never before had the American public witnessed such a spectacle. Two brilliant, confessed murderers, the sons of unimaginable wealth and privilege, facing the hangman's noose. Newspapers from New York to London devoted front-page coverage to every salacious detail. The new medium of radio broadcasts hourly updates. This was, without question, the trial of the century. State's Attorney Robert Crowe was determined to secure the death penalty. For him, this was not merely a murder, it was a crime against civilization itself, an attack on the very fabric of society. Two young men, given every advantage life could offer, had chosen to murder an innocent child for intellectual sport. What greater evil could be imagined? Crowe told the press he would see them both hang. The case seemed open and shut. Leopold and Loeb had confessed. The physical evidence, the glasses, the typewriter, was damning. Multiple witnesses could place them near the crime scene. What possible defense could be mounted against such an overwhelming mountain of guilt? At 67 years old, Clarence Darrow was the most famous and controversial defense attorney in America. A folk hero to some, a devil's advocate to others, he had spent his life defending labor leaders, anarchists, and the most unpopular causes. He was a passionate, lifelong opponent of capital punishment, believing it to be a barbaric relic that had no place in a civilized society. When the desperate Leopold and Loeb families offered him a fortune to take the case, Darrow accepted. But his motivation wasn't the money. He saw this case as his last great crusade, a chance to put the death penalty itself on trial. Darrow's strategy was as brilliant as it was shocking. He would not plead his clients not guilty. He would not attempt to prove their innocence, that was impossible. Instead, on the first day of the proceedings, Darrow stunned the court. Leopold and Loeb would plead guilty to both kidnapping and murder. This masterstroke eliminated the need for a jury trial. Their fate, life or death, would now be decided by a single man, Judge John R. Caverly. This was a monumental gamble. Darrow believed that a jury of 12 ordinary citizens, horrified and enraged by the crime, would inevitably vote for death. But a single judge, an educated, thoughtful man of the law, might be persuaded by a different kind of argument. An argument not about guilt, but about punishment. Everything would depend on what happened in that courtroom. The hearing to determine the sentence of Leopold and Loeb began on July 21, 1924. It would last for over a month, 33 days of testimony, spectacle, and revolutionary legal argument. The nation watched, waited, and judged. Robert Crowe presented the state's case with methodical, righteous fury. He walked the court through every sickening detail of the crime. He called over 100 witnesses. His message was simple and powerful. Leopold and Loeb were cold-blooded, arrogant monsters who deserved nothing less than the ultimate punishment. "These are not children," Crow declared. "These are supermen who believe themselves above the law, above morality, above human decency. If such monsters are not executed, then the death penalty has no meaning in the state of Illinois." Then Clarence Darrow rose to speak. What followed would become the most famous courtroom speech in American legal history. Darrow's closing argument lasted 12 hours, spread across 3 grueling August days. It was not a conventional legal defense. It was something far grander, far more audacious, a profound and moving lecture on human nature, science, and the very meaning of justice. He began by acknowledging the horror of their crime, making no attempt to excuse it. He spoke of his sympathy for the Franks family and his horror at the death of Bobby. But then, he pivoted to the one question the prosecution had ignored. Why? What could motivate 2 young men, who had everything, to commit such a senseless, ghastly act? Why did they kill little Bobby Franks? Not for money, not for spite, not for hate. They killed him as they might kill a spider or a fly, for the experience. They killed him because they were made that way. Because somewhere in the infinite processes that go into the making of a boy or a man, something slipped. For weeks, Darrow had paraded a team of the nation's leading psychiatrists or alienists, as they were then called, to the witness stand. Their testimony was unprecedented in an American courtroom. For days, these experts detailed the psychological abnormalities they had discovered in both defendants, childhood traumas, disordered emotional development, and elaborate, all-consuming fantasy lives that had disconnected them from reality. This was not an insanity defense in the legal sense. Darrow was not claiming that Leopold and Loeb didn't know right from wrong. He was arguing something far more nuanced and, to many, far more disturbing. That their mental and emotional makeup had been so warped that this crime, while not legally excusable, was at least explainable by forces beyond their control. "I know that one of 2 things happened to Richard Loeb. He either inherited a diseased brain or the infinite processes of heredity and environment twisted his mind. He was not his own father. He was not his own mother. All of this was given to him. He did not make himself. And yet he is to be compelled to pay." Darrow's argument was revolutionary and radical. He was effectively putting the philosophy of free will on trial. He suggested that crime was not simply a matter of evil choices, but a disease born of 1,000 tiny factors: heredity, environment, upbringing. How then, he asked, could society justify killing a man for a sickness he did not choose? This line of reasoning outraged much of America. The prosecution ridiculed it. Robert Crow accused Darrow of trying to excuse cold-blooded murder with the quackery of hired alienists. Newspapers decried the millionaire murderers for buying a fancy defense unavailable to the poor. But Darrow was not finished. In his final hours before the court, he moved beyond psychiatry to his true purpose: a direct assault on the death penalty itself. His words would echo through a century of American jurisprudence. "I am pleading for the future. I am pleading for a time when hatred and cruelty will not control the hearts of men. When we can learn by reason and judgment and understanding and faith that all life is worth saving, and that mercy is the highest attribute of man." Darrow spoke of the history of capital punishment, how it had failed to deter crime, how it brutalized the society that practiced it. He reminded the court that Illinois had not executed a minor in decades, and his clients at 18 and 19 were barely more than boys. He appealed directly to Judge Caverly's conscience, his legacy, his humanity. "Your honor stands between the past and the future. You may hang these boys. You may hang them by the neck until they are dead. But in doing it, you will turn your face toward the past. I am pleading for life, understanding, kindness, and mercy. I am pleading that we overcome cruelty with kindness and hatred with love." When Darrow finished, the courtroom was still. Spectators, reporters, and even the prosecution team sat in stunned silence. Judge Caverly reportedly had tears in his eyes. Clarence Darrow had delivered more than a legal argument. He had delivered a sermon on the soul of American justice. For 2 agonizing weeks, Chicago and the nation waited. Judge Caverly retired to consider his decision, a decision that would determine whether Nathan Leopold and Richard Loeb would live or die. The pressure on him was immense. Letters and telegrams flooded his office, the vast majority demanding execution. The court of public opinion had already rendered its verdict. September 10, 1924. Judgment Day. Judge Caverly took the bench to deliver his decision. The courtroom was packed to the point of collapse. Leopold and Loeb sat emotionless, pale as ghosts, at the defense table. Clarence Darrow, for perhaps the only time in his career, appeared genuinely uncertain of the outcome. Judge Caverly began by systematically rejecting Darrow's psychiatric evidence. The mental condition of the defendants, he ruled, was not sufficient to mitigate their guilt or excuse their crime. Leopold and Loeb were legally sane and fully responsible for their horrific actions. A murmur went through the crowd. This sounded like a prelude to a death sentence. But then Caverly turned to a different consideration, one Darrow had emphasized. He noted the youth of the defendants. Leopold was 19, Loeb just 18 at the time of the crime. He reviewed the history of capital punishment in Illinois, observing that the state had shown a consistent precedent of leniency toward young offenders. And then he delivered his verdict. In choosing imprisonment instead of death, the court is moved chiefly by the consideration of the age of the defendants. The court believes that it is within its province to decline to impose the sentence of death on persons who are not of full age. This determination appears to be in accordance with the progress of criminal law all over the world and with the dictates of enlightened humanity. Nathan Leopold and Richard Loeb would not hang. They were sentenced to life in prison for the murder of Bobby Franks, plus an additional 99 years for the kidnapping. They would spend the rest of their natural lives behind bars. But they would live. The reaction was immediate and explosive. Many Americans were outraged. The Franks family was devastated. Bobby's father, Jacob Franks, publicly stated that he had been denied justice. But others saw the verdict as a monumental triumph of mercy over vengeance, of reason over mob rage. Clarence Darrow had not won an acquittal, that was never his goal. But he had achieved something far more significant. He had kept two young men from the gallows, and in doing so, he had forced a national reckoning with the death penalty itself. Nathan Leopold and Richard Loeb, once the privileged sons of Chicago's elite, entered the brutal Illinois prison system in September 1924. They would never again know freedom, but their story was far from over. In prison, both men threw themselves into work and study. They established a school for fellow inmates, dramatically improving literacy rates. Leopold, with his extraordinary intellect, became a model prisoner, reorganizing the prison library and assisting in research projects. Richard Loeb never saw freedom again. On January 28, 1936, he was attacked in a prison shower room by a fellow inmate named James Day. Loeb was slashed more than 50 times with a straight razor. He died in the prison infirmary at the age of 30. The official story was that Day acted in self-defense after Loeb made aggressive sexual advances, a story many historians have since questioned. Nathan Leopold served 33 years. During World War II, he volunteered as a human test subject for malaria experiments that helped develop life-saving treatments for American soldiers. He continued to teach, study, and apply for parole. In 1958, after a campaign supported by figures like the poet Carl Sandburg, Leopold was finally released. He moved to Puerto Rico, married, and worked as a hospital technician, living a quiet, obscure life until his death from natural causes in 1971. But the true legacy of the Leopold and Loeb case transcended the lives of its infamous principals. Clarence Darrow's 12-hour summation became required reading in law schools across America. His pioneering use of psychiatric testimony cracked open the door for psychology to play a major role in criminal justice. The case helped establish the principle that a defendant's mental state, even short of legal insanity, could be a critical factor in sentencing. Most significantly, the Leopold and Loeb case became a cornerstone in the long, contentious debate over capital punishment in America. Darrow's arguments against executing the young echoed for decades, influencing legal thought and public opinion. In 2005, 81 years after Judge Caverly spared the lives of Leopold and Loeb, the United States Supreme Court officially banned the execution of offenders who committed their crimes as minors. Clarence Darrow's dream of a justice system that considered youth, mental condition, and the possibility of rehabilitation had, in a very real sense, finally become the law of the land. A century has passed since Bobby Franks was murdered on a Chicago street. The grand homes of Kenwood still stand, silent witnesses to a bygone era. The participants in this drama, the killers, the victim, the lawyers, the judge, have all passed into history. But the questions raised by this case remain as urgent and unsettling as ever. How do we balance justice for victims with an understanding of perpetrators? How do we weigh free will against the powerful forces of biology and environment that shape us? And the ultimate question Darrow posed: when, if ever, does a society have the right to kill? In the vast archives of the Leopold and Loeb case, the thousands of pages of testimony, the psychiatric evaluations, the confessions, the letters, there remains a gap, a silence, a lacuna. The full, unedited psychiatric reports on both Leopold and Loeb, which formed the basis of Darrow's defense, were sealed at the time of the trial and have never been completely released to the public. What secrets did those reports contain? What details about their minds and motives were deemed too disturbing for public consumption? The gap remains. The Underwood typewriter used to compose the ransom note was never definitively recovered. Leopold claimed to have thrown it into the Jackson Park Lagoon. Divers searched for weeks. They found nothing. Was he telling the truth? Or is that crucial piece of evidence still out there somewhere? A silent witness lost to time. The gap remains. And then there is the deepest, most profound lacuna of all. In their separate confessions, Leopold and Loeb each pointed the finger at the other for striking the fatal blow. The absolute truth of what happened in that rented car. The precise, horrifying sequence of violence that ended a young boy's life, died with its perpetrators. We may analyze their psychology. We may debate their punishment. But the central horror of that moment remains, in its most essential detail, forever unknowable. History is not only what we know. It is also what we cannot know. What has been lost. What was never recorded. What was deliberately hidden. Every story contains its gaps. Moments where the light of evidence fails, and we are left in the darkness. The Leopold and Loeb case changed American justice, but it also left us with mysteries that will never be solved, questions that will never be answered, silences that will never be filled.